Okay, now, good afternoon again. We are here for oral argument hearing in re Energy Thermal Development LLC's application to construct the Clear River Energy Center in Brooklyn, Rhode Island, docket number SB 2015-06. We will proceed with the motion to dismiss first, and we'll go on to the additional motion after that. Are there any administrative matters before?
No.
Then I would ask the attorneys to introduce themselves and the parties. Allan.
I could talk loud enough, you'll hear me anyway.
We want to make sure we can't hear you.
It has to get picked up by everyone in the back as well as the screening.
There we go. Good afternoon. While Todd's setting that up, I'll make some introductions. Allan Shine with the firm of Adler, Pollock and Sheehan. With me also from our firm, to my right, Elizabeth Noonan, Nicole Verdi. Behind me is Richard Beretta. I'd also like to introduce Michael Glaser. Michael is the Senior Vice President and Chief Legal Counsel for Invenergy. He just happens to be with us in the region this today. He has a flight later, but I thought it'd be a good opportunity to introduce him to you. We had a pro hac vice motion for Michael. It was just approved by the Rhode Island Supreme Court earlier this week or late last week. Yeah, it was approved, so he's with us today also. And also John Nyland from Invenergy up to my left, the project developer.
Good afternoon, Mike McElroy for the town of Beretta.
And Max Green, G-R-E-E-N-E, for the Conservation Law Foundation.
I'm Greg Mancini from Rhode Island Building Trades.
Thank you. Mr. McElroy,
Thank you very much.
it's your motion.
Thank you very much. As you know, the town has moved to dismiss Invenergy's application, which was filed on October 29th, 2015, almost 2 years ago. The grounds can be summarized as follows. First, 42-98-8A2 and EFSB Rule 1.6B8 expressly require an applicant to file, quote, complete plans as to all structures, omissions, associated with the proposed facility, end quote. Invenergy has failed to provide complete plans as to all structures associated with the proposed facility. The complete plans, as required by 4298-8A2, quote, shall be the basis for determining jurisdiction, end quote. By law, jurisdictional requirements imposed by statute cannot be waived by this board. And pursuant to 42-98-16A, failure to comply with a board rule or requirement constitutes grounds for dismissal. Now let's get into the detail. 42-98-8A requires the submission, quote, at least, quote, and it lists a number of things. And it states, quote, complete plans for all structures associated with the proposed facility. The complete plans shall be the basis for determining jurisdiction and shall be the plans submitted to all agencies whose permit is required by law, end quote. Invenergy filed a one-page principal and accessory structure list. Note that they've used the word structure, which is the word in the statute that requires complete plans for all structures. This list identifies 55 such structures. They include 2 turbine buildings with a size of 202 feet by 136 feet, 1 administration building with a size of 140 feet by 100 feet, 1 water treatment building, 112 by 64, 1 fire pump building, 34 by 14, 1 auxiliary boiler building, 54 by 45, 2 electrical buildings, 80 by 30, 2 feed water pump buildings, 74 by 49, 1 gas compressor building, 56 by 30, and 1 fuel equipment building, 40 by 20. Those are only some of the structures. 19 of these structures need a variance, and those variances have been requested by Invenergy. But a variance simply cannot be approved without reviewing complete plans for each of the structures to determine A, whether a variance is necessary, and B, and more importantly, whether a variance is appropriate. Now, what plans do we have so far for the 55 structures? For the administration building, we have a floor plan and a second page with preliminary elevations. For that one building only, we have 2 pages. Plus, we have preliminary plans for a project Invenergy is constructing in Pennsylvania relating to the administrative building and the turbine building being built in Pennsylvania. Of the 55 structures, we have plans for the correct facility for only 2 of them. The administration building and the turbine building, and the turbine building plans are from Pennsylvania. We have nothing, 0, for the other 53 structures, except we have a 2-page site arrangement and general arrangement that is virtually unreadable and is attached as Exhibit C to Invenergy's objection in this matter. In its objection to the motion to dismiss, Invenergy flat out states that these 2 pages constitute complete plans for all structures. I've made copies of these 2 pages and I've asked Todd to distribute them, so you should have them on the desk in front of you. Now, on pages 12 to 13 of Invenergy's objection, they have stated, this site arrangement and general arrangement certainly represents plans as to all structures proposed for the facility, omissions. These plans are complete, end quote. I respectfully ask that you simply take a look at it. Do these look like the complete plans for a $1 billion power plant facility? Now, we don't have to go very far to look at what the words of the statute mean. They're plain and ordinary terms. The word complete means, quote, having all necessary parts, elements, or steps pursuant to the Merriam-Webster dictionary. The word plan means a drawing or a diagram. And the word architectural plan means a scale drawing of a structure, all from the Merriam-Webster dictionary. Could these 2 pages, not called plans, but called arrangements, by any stretch of the imagination, be complete plans for all structures associated with a $1 billion, 1,000 megawatt power plant? Could they meet the legal requirement imposed by the Energy Facility Citing Act and this board's rules? We respectfully submit that that cannot possibly be the case. Because the requirement of the submission of complete plans is jurisdictional by statute, we submit that this application should be dismissed under 4298-16A. Invenergy has had nearly 2 years to submit complete plans as to all structures and has failed to do so despite repeated requests from the town. The burden of proof rests solely with Invenergy, not the town, and that's set forth clearly in 42-98-11B. Invenergy has failed to meet that burden. We have filed the appropriate motion and asked that it be dismissed with prejudice. Now, I'd like to address Invenergy's arguments in their objection. One argument Invenergy makes is that it has submitted a, quote, detailed description, quote, of the facility, and that detailed description allegedly satisfies the legal requirement for, quote, complete plans as to all structures, quote. But unfortunately for Invenergy, a description is not enough. It is one of the requirements of the Act. But the Act specifically requires the submission of both, quote, a detailed description of the proposed facility and complete plans as to all structures. This should not come as a great shock to Invenergy. Invenergy has built over 105 energy projects worldwide. They total over 15,900 megawatts. They've also built in that group 10 natural gas-fired plants totaling 5,519 megawatts. They know what's required to build a plant. I don't know why they're not giving it to us, but they have not done so. Now, Invenergy also argues that the town is improperly seeking the, quote, final design drawings and plans, quote, that do not get submitted until the post-licensing proceedings under EFSB Rule 1.14. However, the way this board works is that, quote, complete plans as to all structures must be submitted for jurisdictional purposes to the board during the pre-licensing application process. And then, if and only if this board grants a license, quote, final design drawings and plans, quote, are then submitted in the post-licensing process. I need to emphasize, the town is not seeking the final design drawings and plans. The town is seeking complete plans as to all structures, which is required in the pre-licensing process. It is important to understand the history of the board's Rule 1.14. The board in the Ocean State Power case decided that it needed to set up a post-licensing process, so that in the post-licensing process, the party that had been licensed would submit final plans. The board expressly retained at the time that it established this process the pre-licensing requirement regarding, quote, complete plans as to all structures, and required that they be submitted. They had to do this. And the reason you as a board, not you particular persons, but the board had to do this is because the law was never amended. The law specifically states that those complete plans as to all structures must be submitted. Now, when either a statute or a series of rules that has the force and effect of law, like your rules do, gets amended, and previous provisions remain, by law, that constitutes a ratification of those previous provisions. Therefore, the complete plans as to all structures that have to be submitted as part of the pre-licensing process was ratified when this board adopted the post-licensing Rule 1.14. Now, what kinds of plans are available? Well, for a project of this size, the plans would be awesome. They would be gigantic. I would not be able to carry them into the room without some sort of cart. For a $1 billion project, and in any large project, plans progress through various stages. They begin with preliminary conceptual plans, they move to design development plans, then they start moving into construction design plans that progress in various stages until eventually they are 100% complete and marked as, quote, issued for construction purposes. Prior to reaching 100% completion, the plans are usually stamped, quote, not for construction, quote. This is exactly what was done with the Invenergy, Pennsylvania plans that were submitted to us as an example of what they were going to be doing in Pennsylvania and as an example of what they said they would be doing in Burrillville. Those plans were stamped not for construction. So what we need at least, which is what the statute says, at least, are not for construction plans for each of the 55 structures. We do not need final 100% complete plans issued for construction. We need not for construction plans, and we need them for each of the structures. And only then could the building inspector and this board make a determination as to whether or not the variances that have been requested are appropriate. Now, Invenergy has also repeatedly argued that the board coordinator somehow, quote, deemed complete, and that's a phrase that was repeated over and over in Invenergy's objection. They say that when the board coordinator issued a docketing letter in November of 2015, that the application was deemed complete at that time. That's incorrect. The coordinator has no such authority and did not do this. The November 17, 2015 letter does not even use the word complete, for obvious reasons. He has no legal authority to make such a determination. Only this board has that authority. Under 4298-8B and Rule 1.7, what is the coordinator authorized to do? The coordinator is authorized, quote, to determine whether such application is in the form and addresses the matters, end quote, required by the Act and the rule. The coordinator did that. Determined that it was in the form and addresses the matters. The coordinator did not make a substantive determination as to whether or not the manner in which they were addressed met the requirements of the rules. That gets done through this process, through the evidentiary hearings, and through final vote and determination by this board. He therefore cannot and did not make a substantive finding of completeness, as Invenergy has repeatedly and incorrectly alleged. If this board chooses not to dismiss the application and decides to proceed with the hearings without requiring the filing by Invenergy of complete pre-licensing plans as to all structures, the town respectfully submits that this board will be acting without jurisdiction and will commit a reversible error of law. The bottom line is that Invenergy has demonstrated over and over again that it filed its application before it had all of its ducks in a row. Moreover, even though the matter has been pending for almost 2 years, Invenergy still has not met the requirements of the Act or this board's rules. Enough is enough. We respectfully submit that the application should be dismissed. Thank you.
Thank you, Mr. Chairman, Madam Chairman. I think this latest motion is confusing what complete plans are needed for purposes of allowing the board to review a project like this, as compared to final construction drawings that were referenced. Let me just say first that the comparison to projects that have been built by Invenergy in other places is a red herring. It's a red herring because these completed projects were the result of licensing hearings, conditions imposed, and the preparation of drawings for presentation to the building official, the construction phase of a project. There's a licensing phase, there's a construction phase. And Mr. McElroy, in our view, with all due respect, is mixing up those two terms. As we discussed in our objection, the town's motion to dismiss, again, makes a very similar argument that's been made before, that the information is not complete because permit materials weren't at that time submitted, trying to put the cart before the horse. These motions that have been made before repeat the same type of approach, and this is just, in our view, the latest version. Let's talk about the basic reasons why this motion should be denied. First, the board deemed the application sufficient and complete for purposes of processing the application for review back in 2015, as Mr. McElroy pointed out. And they did so, again, in response to similar motions to dismiss in 2016. Second, even beyond the plans that were submitted in the application, Invenergy has provided substantial details with regard to the equipment and structures that are identified in the application and identified on the general arrangement document that was just put before you. Third, if the town is looking for the type of design drawings and details that would go for construction, as I just said, there's an entirely different process that was set up, and board precedent long ago determined and instructed us that it would be unreasonable to demand detailed design, engineering, and construction type drawings at this stage of the proceeding. That's why the board set up its post-licensing rule, and it's an entirely different process for construction plan review, for building inspector review, state building inspector input, advisory opinion to the board, and a construction review process. Let's look at this in a little bit more detail, because I think it's important that the board have a full picture and not just a sampling, a selective sampling of materials. First, it's undisputed that the board deemed the application complete when it filed the application. The application itself describes the site plans, the layout of the structures, the location and the dimensions of each of the structures, the height, the width, where it will be on the site, where it's to be located, as well as descriptions throughout the application to talk about the primary, the supporting structures, the primary powerhouse building, the turbine, the auxiliary buildings, the fuel oil equipment, the storage tanks, the switchyard, appurtenant equipment, cooling systems, electrical diagrams. I could go on and on. All of it is ignored. The board correctly determined that that application contained enough material to move this licensing process forward. We filed, there's a site diagram, figures drawing that went in with the application. It has the site arrangement, the general arrangement, the shaft construction facilities plan, an administrative floor plan, a one-line electrical diagram, water balance diagrams, site topography, wetland delineation, grading plans. That was just the application alone. The board then reiterated that the application was complete and sufficient for purposes of processing this application in response to other motions to dismiss that I just mentioned. So when the board said, quote, the application at this time already contains sufficiently detailed information regarding the project, it meant what it said. There was enough information already filed to allow this project to go forward for purposes of board and agency review through the advisory opinion process. Now, it's important that we think to identify that there was one moment where we all agreed there was a completeness problem. That moment was when the water supply plan evaporated, to use a word. But even then, at that time, the board did not close the docket or dismiss the docket. The board suspended the docket, recognizing that it was incomplete. There was an incomplete filing before you, and that was a proper determination. In this context, this latest motion by the town is another effort to reconsider a similar motion that was denied earlier. It's masquerading as something new. So obviously we know now, we amended the water supply plan, and the board then determined, again, that information allowed the application to be deemed complete. Now, that's the words of the board. The submission of the plan rendered the application complete for purposes of proceeding forward on the review of the application. So once it's been deemed complete, the town is asking you to say, well, deem this application incomplete now. Well, that's respectfully preposterous. You've made the determination the application is complete 3 times, and it would not be proper to declare now it is not. We didn't stop there, and this is what's important. After the application was deemed complete, the town has requested 1,000 data requests, maybe more if we do an actual count. Many of those requests relate to the buildings and the structures and the equipment for the various components that are described in the application. We responded to each and every one of those requests. Let me just give a small sampling to give you a flavor. In response to the town's data request 2-2, we provided information about the vacuum pumps, the steam jet air ejector technology equipment, the steam turbine drain tank, the air-cooled condenser equipment. In the response to 4-25, we provided information about the fuel or oil storage containment berms, the engineering details around the tanks. In response to 5-11 from the town, we provided details on the unloading station and the piping lineage. And for town request 7-4, information around the ultra-low sulfur diesel storage tanks. And I could go on and on. The stack heights, the details on the demineralized water tanks. All of these equipment and structures were described in detail in responses to data requests. None of that is mentioned in the town's motion. There's also supplemental reports that we know were filed with the board. Of course, there's the water supply plan that we referred to. That plan has an entire attachment from the manufacturer showing the water demineralized trailers, showing specs about the trailers, giving some further detail in data about that. The noise transient operation noise evaluation report gives other equipment descriptions and drawings, and we show the town what that acoustical design material will look like. Similarly, in response to other party data requests, Rydam asked questions about this, the oil storage tanks. There were design drawings prepared in response to that specific request and were provided to the agency. The permit applications all had drawings and materials that were relevant to the equipment associated with each one of these permits. So when you take this all together, you have before you a very robust and well-developed record for review at the final hearings over each of the equipment and facilities and structures that Mr. McElroy is referring to. Transmission facilities, there's an entire docket associated with regard to transmission. We don't stop there. We also provided a number of materials to try to help the building inspector, who seemed particularly focused on this issue. Mr. McElroy provided you just these 2 pages. I'd like to also provide you, just so you have it before you, what we provided the building inspector and filed with this board, if the board would allow that, just for reference. What you'll see is that in October of 2016, we provided the building inspector with a 29-page memorandum describing in detail the proposed design requirements and specifications for the project. In that document, there is an entire section devoted to buildings, which provides structural information and details regarding the buildings. The turbine building, the administration building, the water treatment building. There's an entire section devoted to the structural requirements that the buildings will be designed for. The materials that will be deployed, the specifications that will be followed are described in detail in a 29-page memorandum, not mentioned by the town's motion. Also not mentioned the construction drawings that were submitted at the time from the that were submitted with regard to both the Clear River project as well as the Pennsylvania project. Now, we provided plans with regard to the administration building, showing the elevation of the administration building, a large building on the site for this Clear River project, and we provided site plan, I should say, drawing plans showing the power structure that will contain the exact same equipment that will be deployed in this application. That is the General Electric turbines. Same company, same equipment. Here is what it will, a preview, you could say, of what it will look like. Mr. McElroy dismisses that as irrelevant, but we think it's helpful. It was helpful for the building inspectors to get a look at that, if that's what he was looking to see. None of that is mentioned. There were, I think, 4 pages, single line description of drawings that were provided to the building inspector. These are the materials that were provided to the building inspector. So to say it was just 2 pages is not correct. And by the way, the general arrangement plan that Mr. McElroy refers to is a list of not just structures, but equipment. It's equipment and structures, meaning that the structure will contain a lot of equipment. The administration building, the power train, the powerhouse building is referred to, will contain a lot of equipment. That material is described on this plan. It's shocking to me that none of this is mentioned in Mr. McElroy's motion, in the town's motion. It's as if they do not want you to know about this relevant information. And we believe it is relevant. We believe it is important for the board to understand that we have gone out of our way to try to provide as much information as possible to the town. The town simply refuses to acknowledge that. Now, I mentioned the construction type drawings. It's important, we think, for the board to understand that the board's precedent that I referred to, and this is the Ocean State Power decision, it said, and I'll quote it very carefully, the board said, quote, "It would be impossible for the building inspectors and Department of Public Works to comment with regard to compliance with local building codes, since the specific design and final construction drawings necessary for a building code review are not available, and undoubtedly will not be developed until the board license is granted." That's what I referred to earlier in my remarks. Instead of dismissing the Ocean State Power application, which faced this exact same question that's been raised here, by the way, the board said that, quote, "Common sense dictates that such building permits should not be issued until a thorough review of the design and final construction drawings, and it is unreasonable to require the applicant for a major energy facility to complete detailed design and construction drawings prior to a decision regarding the board license." That last line is worth repeating. Unreasonable to require the applicant for a major energy facility to complete detailed design and construction drawings prior to a decision. And isn't that exactly what the town is demanding? They're demanding that the process be flipped on its head. They're demanding that we have a construction design review done now, before the building inspector, before this board even has a chance to issue a decision after licensing, and to consider what conditions and changes, if necessary, it may or may not require. The board did say in Ocean State Power, if a license is granted, drawings can be developed. That's the quote. If a license is denied, the applicant need not be burdened with the cost of detailed final designs. That's why the board set up a separate process, the post-licensing construction design review process. I hope it is now clear that this motion to dismiss is another example where the town's opposition, strong as it may be, is to try to create this impression that they haven't received what they need to review this application. That is unfair, and we believe it's just trying to create a false impression with this board. So in conclusion, the town has not proved that we have failed to provide the sufficient support that's required by the Citing Act and by the rules at this stage of the proceedings of the review. Because we did file the sufficient level of detail to qualify as complete plans under the statute. And because we've gone way beyond even the materials in the application itself, as I've outlined. And finally, because there's a completely separate review process that comes after the licensing hearings are concluded in the event that the board determines that the license should be granted. So for these reasons, we request that the motion be denied.
Thank you. Just a few brief words. A CLF stated in its written response to Borough Bill's motion to dismiss, CLF agrees with the town that dismissal is appropriate today. Invenergy has gone into great detail, but CLF respectfully urges that the board stay out of the weeds here, as the grounds for dismissal are actually very simple. Section 4298(8)A of the Energy Facility Citing Act says that applications shall contain complete plans as to all structures associated with the proposed facility. The Act goes on to say that this requirement is jurisdictional. In support of dismissal, the town points to areas where Invenergy's plans are incomplete. Invenergy has argued convincingly in its papers and today that it has provided a lot of information. That's all well and good, but a lot of information is not the same thing as required information. It's just that simple. The Act requires complete plans as to all structures, and the town has pointed out that Invenergy has not provided complete plans as to all structures. For this reason, CLF joins Borough Bill in respectfully requesting that this board dismiss Invenergy's application under Section 4298(16) of the Energy Facility Citing Act. That's all. Thank you.
Thank you. I'll be brief also. To us, the town's demonstrated going down every conceivable procedural step to try to stop this project. To the extent this issue could be an issue, which I don't think it is, I think the proper place for it is in the evidentiary hearings of the administrative process. This is the largest construction project in the state of Rhode Island's history. So we urge you to move forward with this on the merits as opposed to a subjective interpretation of the procedure as demonstrated by one of the parties. As the town indicated, enough is enough, and I think enough of the time has gone by, so hopefully you'll decide this case on the merits. Thank you.
Could I briefly respond? Very briefly? Briefly. I will. Thank you. I agree this would be the largest construction project in the state of Rhode Island. We know it's a $1 billion project. We don't think it's too much to ask that it comply with the requirements of the law and this board's rule. With regard to what was passed out to you, we concede all of this. But I challenge you to do one thing, and I would challenge Invenergy to answer this one question. Show me where in this package, anywhere, where there is a single page, other than the general arrangement I handed up earlier for you to look at, a single page that can constitute a plan, never mind a complete plan, a single plan for the combustion turbine inlet filter building, number 1, on that general arrangement. The heat recovery steam generator building, the switch yard, the air-cooled condenser, the fuel oil storage tank, the water treatment building. All of these and more all require variances. All of these and more are structures. By their own admission, it is a principal and accessory structure list. By law, each structure needs to have a complete plan. We don't even have one. And you will look in vain in this package for a single plan for any of those buildings except for the minimal information that was given for the administration building and the turbine building. That's all I have. Thank you.
Council, just on the materials that were handed up by Energy, is it appropriate for us to take those materials at this time?
I believe that you can consider them as part of your decision on the part of the argument that they've made in support of their request that the board deny the motion.
We can't hear back here.
Madam Chair, if I may, we can file that package with the board if it believes it's necessary. Those materials were filed with the board as in attachments to the status report that we filed with the board back in December.
That's what I was not sure of, if it was simply materials that had independently been provided to the town or the building inspector, or if it was just documents and materials that you have in another form already provided to the board.
I certainly believe that the materials in there, maybe not at the last letter to the building inspector, but certainly most of those materials were filed with the board in the application. They're just duplicates. And with the board, as far as copies to our status report that we filed in December, those are all duplicates as well. So to make the record complete, we would certainly offer to file that for the record.
Thank you.
I have few questions from the energy in the town. So it's for you, the applicant. So again, as we just heard, town has some issues. Like again, we are talking about how many structures? 54 structures, 55.
Well, that's really a misleading list because that list of 55, Commissioner, includes both equipment
Okay.
and structure. So the motion is with regard to structure.
So how many structures are there? Approximately.
Certainly less than 10.
Less than 10.
Yes.
And the list which we have over here, and we also have this bigger site plan as part of this packet which you gave us. All the structures are basically depicted on the site plan.
They are depicted in there, yes.
Okay. And we also have this list on the right hand side of this sheet.
Yes.
That basically talks about length, width and height
Yes.
of these buildings.
Yes.
So we also have the length, width and height of all the structures, all the 8 or 10 structures.
Yes, Commissioner.
That will be part of the project.
Yes, you
Right?
do. Yes.
Apart from this, you have also given us this rendering
Yes, I have.
that basically shows us the layout,
Yes.
and it is fairly accurate, right? The heights.
Yes, that rendering was provided in as an attachment to the transient noise report that was filed with the board.
Okay.
Yes. It's to support the noise model.
Yes, yeah.
Yes.
And this, the second sheet which you have is the site plan. This is the zoomed in version of that same site plan.
Yes, one is called the site plan.
Yeah.
The second is what they call the general arrangement layout plan. And they are based on the same configuration of the property, the site itself.
I really think these points have been very well argued, so I'd ask you to be succinct because I think you really have covered it. But to my colleagues' questions, first I would ask the applicant. So Mr. McElroy did say you've only provided plans to 2 of the less than 8 structures. Do you have further that you want to say on the completeness or the characteristics of those plans for those structures?
Yeah, well, what I would say, Commissioner, is that is not true. Because, for example, one of the structures are described as the water tank, or the oil tank. There are plans and drawings associated with those structures that was provided to the town in response to data requests that they've issued, or responses that Ryan issued, I can't recall offhand. So for the town to point to just those two, that's not the complete record. So we would dispute that allegation.
And Mr. McElroy, I think you've made your points well. So I just would ask, given all of the detailed materials that Mr. Shore described after you spoke, do you have any further to say about how you would characterize all of that, the materials that were given to the board or in response to your data request or those other agencies?
I do, and that is, it was in some respects some detailed information. And as I pointed out in my argument, the statute requires two things: that there be a detailed description of the facility, and it uses the word "and," that there be a complete set of plans for all structures. Now, I would ask the board, before caucuses and rules, to please take a look at the Exhibit 1 to my motion. It is a document prepared by Invenergy. It's labeled as Exhibit 1 in the upper left-hand corner. And it is called, not by me, but by Invenergy, Principal and Accessory Structure at the top. It then lists 55 principal and accessory structures. So for them to now be saying that these are not structures surprises me, to say the least. These are the terms they used. The statute uses the term structures, and I challenge them to provide a single plan outside of the general arrangement and site arrangement that constitutes a complete plan for any of these structures, even a preliminary plan for any of these structures, except for the administration building and the turbine building. And even if we just look at those that are buildings that I read to you earlier, there are 2 turbine buildings, 1 administration building, a water treatment building, a fire pump building, a boiler building, 2 electrical buildings, 2 feed water buildings, 1 gas compressor building, 1 fuel equipment building. That's 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. That's 12 that are labeled buildings. Of those, what plans do we have? Now, if you're prepared to accept what I passed out to you earlier, and is Exhibit C to Invenergy's objection to my motion, as complete plans for all structures for a $1 billion largest construction project in the history of the state of Rhode Island, and if you're prepared to rule that that constitutes satisfaction of the complete plans for all structures requirement of the Act, there's nothing I can do about it, except to urge that you not do so, that you either dismiss it, or that you conditionally dismiss it, or that you suspend it until they do file the complete plans for all structures. And given the fact that the hearings begin next month, and we are on the verge of those hearings should be suspended until they submit those plans. I respectfully state that if you go forward without satisfying this jurisdictional requirement of the statute, you will be making an error of law that is reversible on appeal. Thank you.
I have no further questions right
A
now.
question for Mr. Shore. Exhibit B, which was attached to your response to Invenergy's motion, that includes general design requirements for all of the facility buildings?
I think that, yes, it does. It speaks to the general design requirements that the engineering procurement
Can't hear you.
I'm sorry, that yes, it speaks to the general design requirements that the engineering, procurement, and construction company will deploy for all of the buildings.
Doesn't it also have some architectural?
And as well as yes, it does, Madam Chair. It goes into, I might just pull it out here with you. It also goes into the architectural requirements for all of the buildings. It goes into the codes and the standards. It goes into the architectural criteria that will be deployed for all of the buildings. It goes into the types of insulation and interior architectural criteria. It describes the types of materials, concrete, etc. It talks about, as well, the HVAC design criteria for the equipment for all of the facility buildings, the design conditions and requirements, and the codes. Mr. McElroy wants to treat all of that as irrelevant. He wants you to believe that that is not in any way a plan for you to consider, and we take issue with that. The Act and the rules do not have a list, a checklist, a box to check off to say complete plans means a three-dimensional, multicolored drawing signed and stamped by a professional engineer, for example. You could do that. I mean, you could set a rule that would demand that type of level of detail. We don't have it. And we agree with Mr. McElroy that the statute and the term is undefined, which we believe allows the board to consider that the narrative descriptions in this 29-page memorandum specific to the structures and buildings associated with this project can be considered by you as a document that is a type of a plan for how this project will be built. I should also point out that we did offer to meet with the building inspector to get into a specific equipment, a specific structure, if there was a particular concern to try to address that. The building inspector refused to meet with us. We were told it would not be productive. Instead, we get this motion to dismiss. I'll repeat, the town has issued 1,000 data requests to us. If they have a particular question about a specific one building, one piece of equipment, they can ask that and we will respond. If it's a reasonable request, we will respond.
Come on. Oh, really?
Mr. McElroy,
Yes.
are you taking the position that for there to be a complete plan, you need an individual drawing of each structure by itself?
Well, essentially, yes. Now, could they put drawings of two different structures on one piece of paper? Sure. But there should be a drawing of each structure. These are very expensive, very
The
large.
structures are considered in renderings or drawings of the entire site is not sufficient according to your position.
No, it's not. It has to be a complete plan of all structures associated with the facility, and the
And
statute
by
goes...
that, you're saying it has to be a group of individualized documents that contain drawings of single structures?
That's the usual way it's done. Again, if they were grouped together in some fashion, I guess that would be possible, but you would think that for the fact that almost all of these buildings will be multi-million-dollar structures, they're huge, as you can see from the size of the buildings there. 19 of them require variances from the building code. We need more than this. This is simply not enough for a billion-dollar project. It needs to be properly evaluated. In order to properly evaluate it, in order to properly determine the variance requirement, we need to see a plan.
I think the issue over here is, I have a background in architecture, so the issue here is when you say drawing, we need drawings. So drawing is, you're talking about the plans, you're talking about elevations, you're talking about sections of the buildings, or all?
I'll take any.
Any.
We don't even have one, except for the two buildings that we've discussed, the administration building and the turbine building. We have none, with the exception of this that looks down from 30,000 feet. That's all we have.
Because when you talk about plan, someone can easily find the placement of the buildings in the plans from the site plan.
Yes, it's on the site plan.
It's on the site plan, you're right. It's not the individual plan, but it's on the site plan.
I agree, it is.
Okay. And is the town looking for some specific information about some specific building? Or you're looking for more information for all the buildings?
We would like a preliminary plan for each building, especially those buildings that require variances from the town and this board.
Mr. McElroy, then why did the town building inspector refuse to meet with Invenergy, if that's true?
Invenergy was not offering to produce anything to us. They just wanted to talk about it. What we did, as you can see, if you look at our motion, I have attached to the motion an exchange of correspondence between myself and Mr. Shore discussing these issues. It was clear if you read that correspondence, and some of it's fairly technical about the requirements that we were looking at, it's clear that they totally disagreed with us, that they had no intention of producing plans for each structure, that their interpretation of the act was completely different, as you've heard here today, from our interpretation of the act and our building inspector's interpretation of the act. And so if you read the correspondence, I think you'll see why it was our feeling that a meeting would not be productive.
I would just note, and if either side wants to comment on it, that when we're talking about 42-98-82, it seems as though the first part of the requirement detailed descriptions there's no argument about. But the second part, and as you said, it comes down to how do we define something that's fairly generic or general in a statute that asks in a different provision for a liberal construction. It says, and complete plans as to all structures, including, and it goes on. So I just wonder if any of you have comments on that, because I do think, I see where the difference of opinion is, that's clear, but it's, you have said several times, complete plans for all structures, and I'm just, as you look at it, and then further, the one opinion that really spoke to this, it's complete plans as to all structures. And I guess there's a question hidden in there somewhere, which is, if you look at that complete phrase, do you have anything further to comment on? I think we've heard both sides on that.
Personally, I believe that complete plans as to all structures and complete plans for all structures is the same. These are ordinary, everyday words that we used in the statute. They should be given the dictionary interpretation of what they are. We're not looking for anything outrageous here. Please understand, Mr. Shore has tried to persuade you that we're looking for construction design plans that would be submitted as part of the final plans required for the post-licensing process. We are not. We would just like a plan for each of the structures. That's it. A preliminary plan, a conceptual plan, a plan from which we can make an appropriate determination as to whether or not a variance should be granted and whether or not we can move forward with this project and go into the hearings and adequately discuss the impact on the town.
Our response is that it's very difficult to fall into the trap of providing the level of information that is being requested without really going and talking through what exactly they are looking for. We think it's just another trap. They're trying to set up more delay. We're willing to sit down. We were willing to talk to them about this. We continue to be willing to do that. We will explore that if they would like to do that with regard to anything in particular. The information they're looking for is what variance would be needed. Height, width, length, dimensions are the important consideration for variance. That information is already there on the documents for them. Every one of the pieces of equipment and buildings that are referred to have been identified with those dimensions. The level of detail they're looking for is what's unclear.
Could I just briefly respond that we know what variances are needed, because clearly the height of the buildings, and primarily it's height variances that are being sought. The height of the buildings are listed on the document that you have in front of you, so we already know that. But there are two questions that need to be asked. A, what variances do you need? That's been answered. We have it in front of us. But B, are they entitled to the variances? Should they be given? The only way to determine that is to take a look at the plans for the proposed plans for the buildings and to see whether or not there is an alternative that might or might not be better, that might or might not be as high, that might or might not be as obtrusive as the structures that they're proposing here. That would require some basic plan for each of the buildings. Then at that point in time, we could sit down, have a talk about whether there's a better way to do it. Could you do a smaller building? Could you do a shorter smokestack? Any of the things that might be required in terms of determining whether or not the variance is appropriate. We have nothing that we can go on at this point. Thank you.
Aren't those issues evidentiary issues that are considered by the board at the final hearing, or if a license is granted at the post-final hearing proceedings?
Yes, of course they are, but we need to explore those pre-licensing. In other words, we shouldn't be in a position...
At the final hearing?
The statute says that we're entitled to those plans, and the reason for that is because if you don't have the information, how can you possibly adequately explore it at the evidentiary hearing?
Are you also including in your purported definition of complete plan that the applicant should also include all of the different options instead of the current plan that they have for the buildings? You seem to suggest that they should also include alternative ways to design or include the building, changing the height, for example.
I think exploration of alternatives to determine how to lessen the impact on the town is certainly something that should be done. I would think that that would be done once we got a plan for each of the structures. And then we could sit down and figure out, is there a way to make the design less of a problem? Do you really need all 19 variances, and do you need them to the extent that they're asked for here? Does each building, does each structure actually have to be that high?
Wouldn't that also be something that would be included in the board's requirements and restrictions once a license would be granted?
Yes, certainly.
Rather than including all of that in the application?
Well, the statute requires that it be produced with the application. And there's a reason for that.
A complete plan. I'm just trying to figure out how much your definition of complete plan includes.
It does not include an examination of all the alternatives, although I would believe that, as my brother Mr. Shore has suggested, that a meeting would certainly be appropriate with the town and its building inspector to determine, once we have the plans for all the structures, whether there might be a less obtrusive alternative. But we can't do that when we have nothing in front of us.
No further questions? I'm sorry, is there a motion?
Could we discuss this a
Yes.
little bit further before, I don't know if you were about to make a motion, but I think the Ocean State Power decision is really helpful here, and Mr. Shore did quote it, portions of it in regard to this issue. So I think it's, as I said, I think it's been well argued, this jurisdictional issue of what constitutes the complete plan. The fact that the Ocean State Power final decision and order spoke to this in the level of detail, and then subsequently the new regulation on post-licensing proceedings, which really directs that that type of detailed submission of plans before the boards be determined at that time, I think to me is compelling when we look at this general term and how it's been characterized in an earlier decision. So that's what I've been really looking at and dissecting. I think, as you said, Madam Chair, and first, as Mr. McElroy said, it really is a plans that progress through a process. So the question being, what's a complete plan at this stage under the law? And that procedure for post-licensing that requires more detailed construction plans and those to be reviewed, and that the Ocean State decision specifically states that that type of thing will come later in the process. That's been compelling for me.
I do agree. Again, for me, I do think the material submitted to the board constitutes complete plans for this stage of phase of the project, and we can continue with the final hearings.
Yes, I think I agree with that. And that I don't think that complete plans require that there must be a separate individual drawing, as long as all of the necessary information, everything that one would expect to find in a single rendering of each individual building, then I don't see that it provides any additional information or should be required beyond that.
No, that's a good point. Again, what we are looking for, whether we have all the information, whether it's in a plan format or it's in a text format, whether we have all the information for all the structures in front of us or not, whether we have individual plans for each structure or not. Again, I'm looking for information, the plans, what we require to review this project. Whether it's in the text format, whether it's in the drawings, we have the information. Any motion?
Do you have anything further?
No, I really don't. I do appreciate the arguments, and I think we had a thorough discussion of this, so thank you.
I find that the board has subject matter jurisdiction and move that the motion to dismiss be denied.
Why are we surprised?
Second.
All in favor?
Aye.
Aye. The motion to dismiss is denied. I'll give you a minute to move around all your papers.
We're just having a water break.
I guess we can get started on the next matters. And that relates to the August 23rd, 2017 motion filed by the town of Burrillville to first strike Invenergy's objection to the town's data request number 33-1. Second, to compel a complete data response by the applicant to data request number 33-1 from the town. And 3, stay the hearing until all water issues are resolved.
Thank you, Madam Chair. As you pointed out, this is a motion in 3 parts. The first part seeks to strike Invenergy's objection to answering the town's data request regarding Invenergy's alternative water supply plans. The second part seeks an order from this board ordering Invenergy to identify its alternative water supply plans publicly, or if the board finds that their plans are proprietary and confidentially pursuant to the non-disclosure agreement that the town and CLF and OER have all signed already with Invenergy, and pursuant to which many confidential documents have already been exchanged. The third part of the motion is a request to stay the hearings, which is scheduled to start next month, until the Johnston water litigation is resolved and until a wastewater disposal facility has been identified and evaluated by the town and by DEM. As an aside, the board has asked for updates on the status of the Johnston litigation. Yesterday, the parties appeared before Justice Silverstein in the Superior Court. The Superior Court ruled that the parties would be allowed to commence discovery in this case, which now has over 25 parties to it, a number of which have not yet been served or have not yet answered, and therefore discovery will be moving forward soon. But given the complexity of the case, the number of parties in the case, and the fact that rather than being a pure issue of law, it appears Judge Silverstein is going to allow depositions and interrogatories, etc. This case could take quite a while. Going back to Order 107, issued by this board on March 28, 2017, considering the water plan, this board expressly ruled that, quote, the town, as well as every other party to this proceeding, has the opportunity to issue data requests, omissions, to further explore the water plan, end quote. Pursuant to this, the town has issued data request 33-1. This request seeks, quote, Invenergy's efforts to explore additional contingent water sources, end quote. Invenergy has refused to answer. Instead, they filed an objection claiming that additional water sources were confidential and relevant, and not relevant, but admitting that they were in fact looking into this. Earlier they had answered a data request, 32-9, stating, quote, Invenergy continues to engage in sound, responsible business practices through the exploration of additional contingent water sources to supplement the contingency contained in our previously filed water supply plan, end quote. Moreover, in his pre-filed direct testimony, which has already been filed in this case, Mr. Nyland of Invenergy, who also authored that data response, testified that, quote, Invenergy, omissions, is still considering additional, contingent, redundant sources to supply water to the facility, end quote. This is a good thing. In light of the serious challenge to the Johnston water contract, it's a necessary thing. You've got to identify additional contingent water supply sources if this is in any way going to move forward. The question is whether or not this is relevant. They've said it's not relevant, and even if it is relevant, it's confidential. How can this not be relevant? A backup water source is crucial to a plant that requires water. Invenergy acknowledges that. The testimony of Mr. Nyland concedes that they are acting responsibly and with good business practice in pursuing alternative water sources. This board has ruled that we're entitled to take discovery regarding the water plan. These alternative water sources are a part of this water plan, and a contingency that's being developed in the event that the Johnston litigation would rule that that contract is illegal. What the town is saying in their objection, and frankly I think it's outrageous, is, quote, pages 10-11. The town's real motivation for seeking the identities of potential water suppliers, omissions, is so that the town can approach those prospective water suppliers and attempt to convince them not to contract with Invenergy. This is not only an improper purpose of discovery, but may also constitute a violation of Rhode Island law, end quote. There is absolutely no basis whatsoever, and Invenergy points to none, to make this outrageous allegation. For example, the water plan already points to a backup, the Bend Water Company, which would be trucking water. There is a memorandum of agreement to agree. If they decide they want to agree, they will negotiate to try to reach an agreement, is what it says. But there's been no evidence that the town ever approached the Bend Water Company to try to tell them not to sell water or ask them not to sell water to Invenergy. That's never happened. There's no basis in the record for this in any way, shape, or form. Moreover, as this board knows, the town, CLF, and OER signed non-disclosure agreements with Invenergy, pursuant to which much confidential and proprietary information has already been exchanged. All of the parties have been very diligent about making sure that that information is not disclosed in any way. Invenergy has not alleged otherwise. If, in fact, it's determined by this board, and we believe it shouldn't be, because we believe it should be public and publicly vetted and part of the process that the governor has asked the townspeople of Burrville to trust. And in order to get trust in a process, it needs to be transparent and open and discussed with everybody hearing what's going on. So we believe that it should be public information. But if this board determines that it's confidential and proprietary, at a minimum it should be produced pursuant to the NDA to the parties that have signed an NDA. Yet Invenergy has refused to do either. They will not make it publicly available. They will not produce it pursuant to the NDA. How can this town fully evaluate whether or not the water plan is going to have adverse environmental, health, safety, or other impacts on the residents of the town if it does not know what the other alternatives are? It may well be that an alternative that's been identified by Invenergy is one that would be less impactful on the town. Remember the proposal. The proposal is, on an everyday basis, to run huge tractor trailers full of water, about 8,000 gallons of water, 365 days a year, in the winter time, with more coming through in the winter when they switch to oil because of constraints on the natural gas pipeline, going through the small, rural, residential roads of Burrville with these huge tractor trailers every single day. Is there a better way? We believe Invenergy is exploring it. They've essentially admitted they are exploring it as a good business practice. We applaud that. And we say, let us know what you're looking at. We think it should be vetted. We think if there's a better alternative, it should be brought to the attention of this board and the public for us to determine whether or not that other alternative should be pursued. Yet they refuse. They want to hold those cards close to the vest. They simply don't want us to know. This board has the power to order them to answer that question. Now first, from a technical matter, their objection should be stricken because it is improper. The board's rules specifically require that a motion needs to be filed in order to object to a data request. They filed an objection. They know how to file a motion. They filed a lot of motions. We know how to file a motion. We filed a lot of motions. This was not a motion. It's not in compliance with the board's rules. They're now out of time to object, and it should be stricken. Now they say, well, that's form over substance. You know, the objection's basically got the same stuff that a motion would have in it, so what do you really care? Well, you know, unfortunately, as lawyers and as members of a very important board that's looking to possibly license the largest construction project in the history of the state of Rhode Island, the rules in the statute need to mean what they say. We don't get to pick and choose what we want them to mean. This is not Alice in Wonderland, where things mean what I say they mean. And my objection is really a motion, and I say it is, so it has to be. It doesn't work that way. They didn't follow the rules. Their objection should be stricken. By law, if their objection is untimely and stricken because it wasn't properly filed, it's waived. Therefore, the information must be produced. Secondly, as I mentioned earlier, it doesn't make any sense that even if the information is somehow considered to be confidential and proprietary, it wasn't furnished to us under the non-disclosure agreement. We could then have argued about whether it should be made public, but they refused to even give it to us pursuant to the non-disclosure agreement. We need to remember that it was Mr. Nyland who first raised this issue of identifying as a good business practice the alternative water sources in his data response and in his direct testimony in this matter. How does the process work? The process requires the pre-filing of testimony by the parties. And then when we come to the evidentiary hearings, we cross-examine the parties. In the interim, when the testimony comes in, and after the application came in, the parties get to take discovery. They get to ask data requests. What we're doing is we're simply asking a data request about information Mr. Nyland felt was important, and we agree it is important, and he put it in his direct testimony. He said we're looking at alternative water sources, that it's good business practice for them to do so. We're simply saying we'd like to explore that with you on cross-examination. We believe we're entitled to do that. We believe the order of this board has said we're entitled to do that through data request, so we asked it. And they refused to answer. What are they trying to hide? For the life of me, I can't imagine what it might be. Again, for them to claim that we would outrageously violate the law in some way is not backed by any evidence in the record, and they haven't brought forth anything that shows that the town of Burrville was acting inappropriately in any way. So for them to claim that this is the reason why they shouldn't have to answer it makes absolutely no sense. We're approaching the beginning of the hearings at the end of next month. It's scheduled for 17 non-consecutive days through January of 2018. There are many, many people involved in these hearings. In addition to the three of you who all have very demanding, very time-consuming day jobs, to set aside these 17 days for hearings, take you away from your jobs, you better be ready to go. The ducks better be in a row. The ducks are not in a row. But in addition to the three of you, by my count, and I could be off by a few lawyers or two, but I count 18 lawyers. There's 6 of them sitting here today for Invenergy. Okay? I count 37 witnesses. There are 12 agency opinions. In addition, there are supplemental opinions. The service list of interested parties has approximately, almost exactly 100 members of people who are interested enough to be on the service list and get the volumes of information that's coming through. Do we really want to go into the evidentiary hearings next month with a water plan that could be declared illegal by the Superior Court and face the filing of another alternative water plan that we haven't taken any discovery about, that would need to be reviewed by all of the advisory agencies and would have to be explored by the parties and by this board? We submit that that makes no sense. In this regard, I'd also like to point out that one of the most important sections of the existing water plan deals with wastewater. This is because the Energy Facilities Citing Act specifically lists both water and wastewater as issues that this board must explore and rule on. Yet to date, 2 years into the process, Invenergy has identified no agreement with any trucking company that will truck the wastewater, nor has it identified a single receiving facility for its wastewater disposal. DEM, in its recent supplemental advisory opinion, said that it cannot provide any opinion on the impact associated with the wastewater disposal without a specific receiving facility being identified by Invenergy, which it still has not done. It doesn't sound to me like that's rocket science. Again, apparently they don't want to disclose to us who they might be negotiating with to receive the wastewater, but it's very important. DEM needs to look at a number of issues regarding what will be in the wastewater, whether the facility is licensed to accept the types of things that will be coming into the wastewater, whether the volume can be handled. There are a number of issues involved in this, yet it's incomplete. So how can we go forward with hearings next month with a water plan that has significant legal challenges without an identified water treatment facility that can be looked at? Invenergy claims that, don't worry about it. Ben Water is going to step up to the plate if Judge Silverstein declares the Johnston contract to be illegal. And they attach to their water plan a 3-page document that they call an agreement with Ben Water. But if it's carefully looked at, it is far from an agreement. It is a non-binding letter, memorandum of agreement, that is an agreement to agree. It's what we call, in first year of law school, an illusory contract. It's not binding on anybody. We need to explore a number of issues with regard to any backup water supplier, whether it's Ben or whether it's one that gets identified by this board requiring Invenergy to disclose those water suppliers. We need to look at whether or not they have the capacity to serve it, whether the water source is adequate. These are all the things that are listed in the Ben Memorandum of Agreement. That's under the due diligence section. It says, Ben, if Invenergy calls on you to step in the event Johnston goes away, we're going to have to do some due diligence first. What are we going to have to do? We're going to have to investigate your, quote, source water, your water chemistry, adequate volumes, and Ben's ability to deliver the required volumes both in the summer and the winter, end quote, when, as we know, water needs a spike. Does this sound like a backup plan that you have confidence in? It doesn't feel that way to me. Now, I'm very glad that Invenergy mentioned in their objecting papers 2 decisions of the EFSB here a number of years ago in the Manchester case and in Massachusetts in the Exelon case, which was recently decided at the end of 2016. Let's look first at the Exelon case. Invenergy says, well, you know, they allowed the contract with the town of Millis to be filed after the fact because that contract hadn't been finalized. So the EFSB in Massachusetts says, well, you can file that water contract before you begin construction. Well, that's true. But what did they omit regarding that case? First, they omitted that the Millis contract was only a secondary water source for them. The primary water source is a well that is drawing water from the Charles River. That well is capable of providing 51,840 gallons per day out of the 68,800 average gallon per day needs of the plant. That's on page 83 of the order. Also, because they hadn't finalized the contract with Millis for this secondary source of water, Exelon identified water trucking companies as a third source of water that could possibly meet the water needs in place of a contract with Millis if Millis fell through. But the citing board in Massachusetts did the right thing. They said that because Exelon did not present an analysis of the environmental impacts or the traffic impacts of trucking that water, the EFSB was going to limit Exelon to using trucked water only as a backup temporary contingency. So what does that tell us? It tells us how important water to a power plant is, and it tells us how important it is to make sure you've locked it down. That not only that you have a primary source, but that you have a backup source, and that it be a reasonable and source that has the least environmental impact that it possibly can. Until you know what those sources are, you cannot evaluate it. Let's now look at Manchester Street. What happened in Manchester Street? In Manchester Street, this board identified a well site in Olneyville to provide the water to the plant through a pipeline. That was approved, but through the development of the evidence in the case and the examination of the site, the board indicated that it had some concern about whether the Olneyville site would provide sufficient water. So what did the board do? To show the extraordinary amount of power this board has and the extraordinary amount of attention that it is paying to making sure that a power plant has sufficient water at all times, this board ordered the developer of the Manchester plant to, quote, obtain ownership and control over an alternative well site that could serve as a supplemental water source. That is at page 25 to 26 of that decision. Now these EFSB decisions show just how important alternative water supplies are. This is exactly the information the town is seeking to pursue. What are the alternative water supplies? I don't know why Inventing doesn't want to provide it. Their reasons make no sense. They're not based in any fact. And the town believes that it would, again, be an error for this board to move forward with the hearings while the Johnston water contract faces serious legal challenges to its validity, when no firm backup contract for water has been identified, and when no wastewater receiving facility or trucking firm to take the wastewater has been identified so that DEM can take a close look at it. We therefore respectfully submit that A, the objection should be stricken, B, this board should order that the alternative water sources being considered be produced publicly, in this case, or in the alternative, if the board finds that the information is confidential, that it be produced pursuant to the non-disclosure agreement. But again, we urge this board to find that it should be publicly explored to give the public confidence, faith in the process, a transparent process that everyone can see. And finally, we ask that the hearings be stayed until such time as the issues regarding the water plant, the Johnston contract, the backup contract, and the receiving facility for the wastewater are sufficiently solved. Thank you.
Thank you. May I just begin by reading the actual request, because I think it is characterized differently in Mr. McElroy's argument. The request that this motion is referring to, that is the motion to compel, asks, please set forth in detail all of Invenergy's efforts to explore additional...
Is this data request
Oh, sorry.
33-1?
Yes, Madam Chair. Data request 33-1. Please set forth in detail all of Invenergy's efforts to explore additional contingent water sources to supplement the contingency contained in your previously filed water supply plan. Please identify any and all additional possible sources of water that have been considered or explored, including but not limited to the location of the water supply. Now, first, there's no dispute that it's important that the board have before it any additional or other contingent water supply plan agreement that has been reached between Invenergy and anybody. Because at that point, that is a real alternative. It is a real contingency. Until you have a formal agreement with another party to provide water to Invenergy, that is not an alternative. That is not a real contingency. It is a wish, I hope, I wish they would agree with me, I wish that company would supply. That's not the purpose of providing you a water supply plan. The purpose is to provide you a water supply plan that is real. The question that's been asked here is to provide you not what's real, but to provide, well, who are you talking to? Who are you negotiating with? Who do you think has water out there that you might be interested in? That's not a relevant source of discovery, because the board is to review a water supply plan, a real plan. That's important. So I believe, and I would suggest that Mr. McElroy is not asking in his data request 33-1 for us to identify a water supply alternative plan. He is asking that we disclose who are we negotiating with. And that's an important distinction. And the reason why that's an important distinction is because it is well established that no party has a right to sit in your telephone, in your office, at your conference table. A party particularly that is opposing you and wants to see you fail. A party that wants to see a water supply supplier that you might be interested in not provide you water. And we have experience, we're not just making that up. When we approached the city of Woonsocket, reached an agreement with the city of Woonsocket, when it was presented to the council, as it should have been, and as it was, the town did everything it could to oppose the entry of that, the full entry of that water agreement. And we don't have a problem with that. That is absolutely their right. That was a public proceeding. They voiced their opposition. The council decided we did not get a water supply agreement with the city of Woonsocket. So our fear that they are seeking information about who we are negotiating with is a very real fear, and what they might do with that. It is that reason that the courts have said a party is not obligated to disclose who they are negotiating with. The Providence Journal versus Convention Center case, which we cited in our objection, is helpful, is on point. That's a 2001 Rhode Island Supreme Court decision. The newspaper was looking for information from the Rhode Island Convention Center on who it was negotiating with to provide services to a golf tournament, a banquet at a golf tournament. Why they were looking for that information is not relevant. The point that I want to make is that the court went out of its way to say that information related to negotiations are not subject to disclosure because it's obviously highly confidential as related to a prospective or a potential business customer, but that it's also protected because the information can be used to prejudice the ability of a company to reach an agreement in the first place, to actually have a business arrangement. So requesting that information in the form of a data request is not relevant to the water supply plan that you have before you, and it's outside any reasonable discovery request. It goes beyond the line. And that's why we objected to it. If there is another alternative water supply arrangement that agrees to provide water, we will see that agreement. We will provide that to you. Until that point, we are merely speculating. And and the town has no right to know what we're speculating, who we're speculating maybe about. That's not the role of a public process. We've had a water supply plan filed with you. That plan described in detail what the town of Burrillville said it needed to have in order to meaningfully evaluate the plan. The items were listed in detail. There were, I believe, 9 items, if my count is correct. At no point in there was there a requirement that there be an unchallenged water supply plan. There's nothing in that plan or in the list of ingredients or components of the plan that say, oh, number 10, also tell me who you're talking to, who else you're talking to. That does not appear in the water supply plan. So that's the reason for the objection. Now, with regard to the water supply plan itself, we did identify an alternative contingent backup, the Ben Water Trucking Company. That backup alternative plan or supplier is unchallenged. And this leads to the argument about the motion to stay. Oh, before I turn to the motion for stay, I would just, unless I completely missed something, there's not a single reference in the town's motion to compel or the motion to stay for the wastewater issue, which they've raised in their arguments. As far as I can tell, that is an entirely new argument. Not to mention that it's a recycled argument, I think, in another way, to say that the plan is not complete. We filed testimony about the wastewater plans and options. There's been rebuttal testimony about that. That's an issue for the evidentiary hearings. There have been numerous data requests about it. The fact that there's not a contract, well, before the board with a particular wastewater receiver, that's not a reason to stop the process. That's a reason to go forward, to ask questions about it and what the prospects are, what the likelihood is, and so on and so forth. That's an evidentiary issue for the board. With regard to the labeling of the motion as an objection or a motion, that is semantics, we would argue to you. We provided everything that the board requires in their motion in the objection. Mr. McElroy's been practicing law, certainly as long as I have. We've been around, you could say. We know when somebody objects to a discovery request that it's an objection to a discovery request. Whether it's called disagreement, whether it's called a motion, whether it's called, no, I'm not going to provide it to you, and unless. He knows what that is. There's no reason to go on and talk about that anymore. That's really silly. Now, with regard to the motion to stay, remember, we filed the water supply plan. The town moved to dismiss the water supply plan after it was filed, after all of the items were provided, after the details were provided to you. They moved to dismiss it. And they moved to dismiss it for the same reason they're asking you to stay it here today. Because the contention was the city of Providence is opposed to the siting of the proposed facility and the possibility that the water plan may face legal challenges. They raised that argument with you in the context of the motion to dismiss. That's the same argument they're raising today. The board already said the submission of the plan itself is what rendered the application complete for purposes of going forward to hearing. The fact that there may be a challenge is not relevant to you moving forward. The town opposes this project. The town has challenged the water supply plant. We disagree with their challenge. We think they're wrong. We think the court will agree with us. That's for the court to decide. I want to point out that he mentioned that there was development in court yesterday. Yes, there was. The development in court yesterday was that there was a status conference with the judge. There was no order issue. We don't have a written determination. Our understanding is that the judge has allowed limited discovery. Not anything and everything under the sun. Limited discovery. Number two, with respect to the City of Providence, the City of Providence filed its answer yesterday to the complaint. They answered it on behalf of the defendant, the City of Providence. They did not jump over the V in their answer to the complaint to become a plaintiff. They answered as a defendant. As far as we can tell, they are defending that claim. We're waiting for the Providence Water Supply Board's answer, which we expect any day. So a stay is not warranted under these circumstances. Mr. McElroy mentioned the Manchester Street Station. Again, the point of the Manchester Street decision is that the water supply plan that was put before the board had some questions to it, had some concerns to it. The board was concerned that the plan that was submitted in Manchester Street would not give you enough water to provide enough water for the project. They were concerned about the capacity of the water that was being supplied. The board did not stop the process and say, we won't go forward any further until we have more details, until you present an unchallenged additional plan. The board conditioned its license and said, we have a problem with your water supply plan. We'll give you a period of time to go develop alternative supply sources and report back to us. If you can, thank you, let us know, we will review it. If you cannot, and if you determine you don't have enough water supply, well then you're going to have a real problem. That was the way the board handled it last time in Manchester Street, and that was the point we raised. So that the town's claim that an unchallenged, I quote, confirmed final and unchallenged water supply plan is necessary to proceed to final hearings is simply wrong, and it's not supportable. And they have been provided the information to meaningfully evaluate the water supply plan. Because the sufficiency of our water supply plan, as well as the backup contingent alternative source that we've identified, will be considered at the hearings, a stay is unwarranted, and the request to stop the proceeding again should be denied, and we should be allowed to go forward.
May I be heard briefly?
Did you join in this one also?
We did not file any written papers.
Should I?
I don't think it would be appropriate if they did not join the motion to be arguing.
It's up to the board.
I think that, yeah, I think because you didn't join the motion, that it wouldn't be appropriate for you to offer arguments.
Could I respond briefly to some of the points my brother has mentioned?
Okay.
Basically, what Invenergy is saying is they want to continue to be able to hide the ball. They said, oh, you know what, until there's a signed alternative water source contract, we don't have to give it to you. We don't have to show it to anybody. They can then control the entire process. They keep that agreement, they reach a handshake agreement, they reach a verbal agreement with somebody, and they say, you know what, we can't sign it just yet because we don't want people coming all over this thing and taking a close look at it. So we'll sign it later. And if you adopt the rule or the proposal that my brother has suggested, they'll be able to do this for as long as they want. They would control when the public learns about these alternative supplies. They would control when the board learns about it. They would control whether or not it could get vetted. That's not at all what this public process is meant to be about. Second, my brother has cited the Providence Journal case. Apples and oranges. The Providence Journal case is an Access to Public Records Act case, the APRA. The APRA has a long list of exemptions in it. It's for public agencies that are subject to the APRA where Access to Public Records Act requests can be made. If a request falls within one of the exemptions that have been determined by statute to be protected, you don't have to produce it. And these negotiating documents that my brother talked about, he's right. For the Access to Public Records Act purpose, don't have to produce them. I get that. This is not an Access to Public Records Act case. This is a case by your own rules. You're governed by the rules of the Rhode Island Superior Court regarding discovery. Those discovery rules are completely different from the APRA. Those discovery rules say that if your request is reasonably calculated to lead to the discovery of relevant evidence, you get it. It doesn't have to be relevant. It has to be reasonably calculated to lead to the discovery of relevant evidence. The exemption that my brother spoke about regarding negotiations with me listening in on his telephone only applies to the APRA, not to this proceeding. The Ben contract. My brother said it was unchallenged. Well, we haven't had the hearings yet. It is definitely going to be challenged. And I'll just briefly point out that in addition to it being an illusory contract, which you can see by just looking at it because it's in the papers, Ben is a pool company. They fill pools primarily with water. According to their LinkedIn website, they have between 2 and 10 employees. Are you comfortable that if the Johnston contract goes away, that this company is going to be able to keep this 1,000 megawatt power plant running 365 days a year? We'll explore that. Believe me, it's not unchallenged. The wastewater. The wastewater is absolutely not new. Wastewater has been discussed from the beginning of this application. The reason I mention it is because DEM just issued a supplemental advisory opinion recently.
But you didn't raise it in the papers.
I did not raise
so
it.
on the
I did not raise it in the papers. I read it in the recent supplemental advisory opinion, and I said I need to bring this to the attention of the board. It's the
Not
waste.
on this motion.
Well, the wastewater is part of the water plan, and it's a further reason why we believe that this case is not appropriately in position to move forward and should be stayed until the problems that I've identified have been cleared up. And one of those problems needs to be an identification of the receiving entity for the wastewater. Thank you.
The motion to strike and the motion to compel are procedural motions that can be simply ruled on by the chair. As to the motion to strike Invenergy's objection to data request 33-1, the objection is not effective. So the objection is not struck. The motion to compel a complete response to data request 33-1 is denied. The matter that it seeks is completely speculative. It's not relevant at this time. If there were an additional agreement reached with any other entity for another water supply plan, then that certainly would have to come before the board. But at this point, there is a water supply plan, and speculative discussions that the applicant may be having are simply not relevant at this point to this matter. That brings us to the motion to stay until all water issues are resolved, and I think we should discuss that. I think that also is the fact that the water plan is being challenged outside of this forum. I don't think it's relevant to whether or not we should continue forward to position.
I just want to ask Mr. McElroy, our regulations have a rule on suspension, 1.15, excuse me. I just, since we don't have a rule on the standard for stay, I wondered what, and you didn't address it in what you filed, what you thought the standard for stay was.
Could I just look at the rule for just a second? Yes, I think you've hit the right rule. I don't see there being a difference between a stay and a suspension of proceedings. I think they're the same, so I think Rule 1.15 would apply.
I don't have any further questions, Madam Chair.
Neither me.
Did you have any argument or position or thoughts? It's not a motion.
I would simply, obviously, we are paying attention to what's going on in the separate forum, which is at Rhode Island Superior Court. And, depending on what decision they might make, or a Rhode Island Supreme Court, potentially in the future, that would be something we would have to take seriously and address. So I think, as the applicant mentioned, it is a separate forum entirely, and so I appreciate the points that Mr. McElroy made about the time that we're spending. I think other than tracking that and addressing it either in a license decision, were we to get to that first, or when a decision is made, is the right course. It bears repeating that Invenergy has the burden of proof to show that each of the elements in the Energy Facility Siting Act 42-98-11B are met, that the project's needed, cost justified, will not result in unacceptable environmental harm, will enhance the socioeconomic fabric of the state. Under that same section, the board may make a decision with any condition we want to impose based on the record. So I do feel that many of these issues are issues that will need to be discussed and vetted during the evidentiary hearing, but that the proceedings that are occurring in another venue are separate from what we're doing, but something we need to take notice of.
Do you want me to make a motion?
Or if you have
No, I
any-
do not have anything to support that.
I agree that we currently have a complete application before us. It includes a water plan, that is the revised water supply plan. If indeed the Superior Court decides to rule in a way that invalidates that water plan, that's a very, very different problem for Invenergy. That's not the problem that it's facing right now, though. So I think it would be appropriate to deny the motion. Is there a motion on the motion?
I move that the motion to stay the proceedings be denied.
I'll second.
All in favor?
Aye.
Aye. The motion to stay the proceedings is denied. Is there anything further? Thank you very much. We're adjourned.
Do I need to move to adjourn? I move to adjourn.
Second. All in favor, say aye.